asked if we would just stand up and relinquish it to folks that need to go to folks. It is a pension bill.
We are live, by the way.
We are live. This is Senate Finance. And we are, as of this morning, I believe we have 10 bills on the wall. I'm going to try and get 4 or 5 of them out today, plus hear any amendments that come in for 887. Chris is here. This is our pension expert, and we don't have, Rick is not supposed to be here for 10 minutes. But it's money, so if you could tell us what this bill does and why.
Sure, for the record, Chris Crook, Joint Fiscal. Madam Chair, the bill you are referring to is H 585, which pertains to pension benefits for sheriffs and deputy sheriffs in the state employee retirement system. I will preview this by saying that the bill is not expected to have a significant impact to the state's obligations to the pension system. What this bill basically does is, a few years ago, when you all, I think everybody around this table participated, when you all voted for Act 114, the big pension task force bill, you created a new benefit called Group G for corrections officers to transfer into, where they would be able to have an enhanced retirement benefit at age 55 with 20 years of service. The catch was the employees pay a higher contribution rate into the pension system to pay for the present value of that higher benefit under Group G. So the cost of Group G is revenue neutral to the employer. The sheriffs and deputy sheriffs that participate in VSERS also pay their own way for their pension benefit, so this does not impact the state budget anyway. What this bill would do is allow deputy sheriffs and elected sheriffs who are currently in Group F with all the other general state employees to also transfer into Group G. Why is this a significant issue? There are a lot of inequities right now in pension benefits with law enforcement. If you're a state paid transport deputy, you're in Group C, and you already have the ability to retire at 50 or 55 to 20 years of service. If you're in the municipal system in VMERS Group D, you already have the ability to retire at 55 and 20. But if you are a deputy sheriff or a sheriff in VSERS Group F, you do not have that ability. So this has been something that I know the sheriffs have been very concerned about for a long time, because it has been difficult to recruit and retain when there are other similar positions out there that have the more enhanced benefit to retire at 55 and 20. So what this bill would do is create, and Rick can walk you through the specifics when he gets here, but it will create a transition mechanism very similar to what you all passed in Act 114 for the corrections staff, that allow existing deputies and sheriffs an opportunity to make a one-time irrevocable choice to move from Group F into Group G. And beginning January of 2025, all new hires would be automatically enrolled in Group G. The hook that triggers your committee's review is that folks who are in Group G pay a contribution rate that is 4.68% higher than they otherwise would pay had they remained in Group F. But otherwise, this doesn't have any sort of impact to the bigger picture of the budget. This is really a sort of a mechanical thing that impacts revenues going into the retirement system. Your colleagues in the Committee on Government Operations added one other provision to the bill. You will see that Section 6 contains the Pay Act language that pertains to sheriffs, which is also in the Budget Committee of Conference report that just closed earlier today. So they didn't make any changes to the Pay Act salary, but what they did do was add some provisions that say, under current law, if you are an elected sheriff and you have not obtained a level 3 certification, your pay is reduced by 10%. What they did was clarify that to say, if you have a level 2 but not a level 3, your pay is reduced by 10%. If you do not have a level 2 or level 3, your pay is reduced by 20%. And if you do not have a law enforcement certification at any level, your pay would be reduced by 30%. And this pertains to the state salary piece. This is expected to have a negligible fiscal impact,
It would encourage people to get the level of certification.
or at least maintain it. And I think that some of the express legislative intent here was, and you'll see that in section 5, that the sheriff's compensation should correlate with their level of law enforcement certification to properly reflect the sheriff's capability to perform the varied duties required to effectively and efficiently manage the law enforcement agency.
Okay, but our area of jurisdiction is impact on the revenues of the state by allowing, it will allow now, can present deputies stay in the category C?
Or in F. So this doesn't have anything to do with the folks who are already in C,
Yeah.
they stay in C.
C is where you want to go. It's got the enhanced benefits.
C is where the state paid transport deputies
Yeah.
and the state police are. This doesn't have anything to do with group C. Group G has a somewhat similar benefit. So it's sort of a hybrid between group C and group F. The fiscal note will walk you through in excruciating detail how these different groups differ from one another. But to your point, this does provide folks who are currently employed with an option of staying in the benefit they're in if they don't feel that it's advantageous for them to switch groups. So if you're later in your career and you've got 20+ years of service, you may not want to switch into group G and pay more. But if you are starting out in your career, it may be more desirable to be in group G.
And new hires will all.
They
be in-
automatically,
Be in.
correct.
Because it's an enhanced benefit, then an enhanced amount has to be put into the pension fund, so the pension fund is held
Yep.
whole when it.
And that incremental additional cost is borne by the employees themselves.
I remember when municipals came in, their choice was there was a one-time
Yep.
payment to make up for getting the enhanced benefits that the state police had. So,
And I just wanted, before you organize, Senator Barr, I just wanted to mention, since you mentioned the muni system, that previous conversations around sheriff pensions have explored the idea of moving from VSERS Group F into VMERS Group B. And that was found for various reasons to be unworkable. So this bill very explicitly does not allow transfers from one pension system into another. This is very narrowly tailored to folks who are in VSERS Group F now and allow them to move into VSERS Group G.
Senator Brock, you had a question?
I do. Does this apply to deputies only and not sheriffs?
Both.
Both. On the issue of sheriffs, I know that the resolution that is passed by the House talked about the sheriff who lost his certifications. And I know there was some talk, and I don't know if it was in the resolutions or anything else, about changing his pay grade by reducing that 30%. Is there any something done along those lines?
So I would absolutely direct this question to legislative council when they arrive, because it's more of a legal question, but there are provisions that in section 6, as I mentioned about the salary reduction for
Right.
not having.
Level 3.
Right.
Level 3 too, but is
So-
there anything beyond that in that you're aware of at this point?
Not that I'm aware of, other than, yeah, if you possess no certification, this would call for a 30% reduction.
Well, that was my point, because that's what happens when he lost his certification. And so that would be a 30% reduction, and is that new or,
That is new language.
and that's new language in this provision?
And that pertains to the state portion of the salary. Obviously, some sheriffs can find other avenues of compensation through their office, through some of their contracts.
Well, there's a base for the sheriffs other than Chittenden County, I think that's what, 90-some thousand years of.
Yeah, you will see that in table 3 of the fiscal note. It is currently in FY 24, roughly 97.7,
All right,
and for Chittenden, it's 103.
So
And
maybe
that-
we'll put Rick up there, because he's the drafter, and he can tell us what it says.
and so that 30%, this would be effective when, this, you know?
Yeah. I'm gonna phone a friend for Ledge Council, whether this is effective on passage or January or July 1.
Okay.
I'm just not sure.
Yeah,
Okay,
I think
thanks.
we'll switch seats and Rick can come on up.
Hey, are there any other questions on the fiscal?
I don't think so. This was pretty clean. Nobody's.
Thank you, Madam Chair.
Thank you. Welcome to the end of the session in finance. We're pounding out 5 bills this afternoon
Okay,
and a few amendments.
is this the end of the session? I have not heard.
I think it is.
This is my first everything. Everything's fun. Rick Sagal, Office of Legislative Counsel. Good to see you all again. Do you want to share my screen or just?
Yeah, people at home can see it, so
Sure.
if anyone's watching all this excitement.
So I'll say while I'm loaded on my screen, I'll say Senator Brock, my colleague Tim Devlin wrote that portion of the bill. I will attempt my best to indicate, I know the effective dates, but as far as the intent, I'll have to maybe defer to him. Zane, can you send me a calendar? Yeah, thank you. While I wait for that, I will begin, and I'm sorry, I'm not sure what Chris covered, but I'll start from the beginning. I assume he told you all that we're moving sheriffs into Group G, or they've been given the option to move into Group G. So Group G was created a couple years ago for Department of Corrections employees. And just like we really kind of reused a lot of that language, which made my job easier. One of my previous colleagues had set this up for me. So I appreciated that.
It's just wonderful, isn't it?
It really is. Thank you, Wasserman. So make sure I have the right document shared here. Are you working? Oh, there we go. Okay, there we go. All right. So section 1, really page 2. We are creating a new group, well, not a new group, a new group of people put into Group G. And those are sheriffs, all sheriffs, and deputy sheriffs who meet certain qualifications. Those 4 things, AA, BB, CC, and DD. All this language was vetted by the Treasury Department to ensure that we're not missing anything. So they gave this the green check mark. But if a deputy sheriff does not meet one of those requirements, they're likely in municipal retirement, Chris, is that what it is? Or they're in Group F, one of those two?
Which,
The deputy sheriffs who are not going to meet AA, BB, CC, or DB.
correct, if they are not AA, they would be in the VMERS
Right.
system most likely, and if they're not BB, they're likely not employed.
This was all language that was compromised, not in a bad way, between the groups. So, again, those are the groups eligible to transfer.
Deputy sheriffs that are not eligible now
Right,
to go to Group F, Beavers F, right? Which has an enhanced benefit of retirement at age 55 after 20 years. So this bill makes them eligible. And I assume there's a payment in here somewhere?
there's a payment for an appropriation, or
No, do they have to make an extra payment? here?
they're what is it called? Their payments to the system increase, yes.
Okay,
Percentage wise, yes,
okay,
yes.
but there's no buy-in payment,
No.
okay.
So down to the normal retirement date. Again, we're using language that the Department of Corrections employees received, the put in Group G. It is the same exact language depending on when you were hired. If you were hired and in the system, on or before June 30th, 2008. And still employed as of December 31st, 2024, and you decide to join. By the way, you don't have to join Group G. You can decide to stay in Group F. And the Treasury Department testified that only a third of corrections employees opted in the Group G. So some want to do it, some don't. It's not really a bonus.
You wanna
group.
have your money now or have more in your?
Retire earlier, it's a different benefit. So if you're hired on or before June 30th, 2008, your normal retirement is 1, 2, or 3, 62 years of age following completion of 5 years of service, completion of 30 years of credible service, or 55 years of age and following completion of 20 years of creditable service. If you were hired after July 1st, 2008, and are still employed, your normal retirement is the earlier of 65 years of age and completion 5 years of service, attainment of 87 points, reflecting the combination of the age of the member and number of years of service, or 55 years of age and completion of 20 years of creditable service. If you were hired on or after January 1st, 2025, your first day of retirement is the earlier of attainment of 55 years of age and completion of 20 years of service, or 65 years of age and completion of 5 years of service.
But the important thing to this committee, Hobbs will cover that.
Yeah.
Is that this is expected to have no impact on our pension
Sure.
system.
That is what JFO has said. I always want to give full disclosure
no.
in case the committee wants more information, but
Yeah. 6 weeks ago, we had that option.
understood, Chair. I can skip ahead. I will start when it comes to the reduction in pay.
Okay,
There is intent language that was added again. My colleague Tim Devlin wrote this, but section 5. It is the intent of the General Assembly that a sheriff's compensation shall correlate with the sheriff's level of law enforcement officer certification to properly reflect a sheriff's capability to perform the various duties required to effectively and efficiently manage a law enforcement agency that is the office of sheriff. So that's the idea here. We heard testimony that if a sheriff does not have a certain certification, that they can't carry out certain parts of the job. So with that said,
there you go.
section 6 amends the sheriff compensation language in statute. You see, this is pay act changes, I believe. These numbers here are just straight from the pay act.
That's why it's going to a vote. So,
Subsection B, compensation, this is just for sheriffs, not deputy sheriffs, just for sheriffs. Compensation under subsection A of the section shall be reduced by 10%, that's already in statute, for any sheriff who is level 2 but not obtained level 3. And we're adding level 2 to clarify what's to come later here. You'll see in a second why that's important. New language, compensation under subsection A of the section shall be reduced by 20% for any sheriff who has level 1, not obtained level 2 law enforcement officer certification under 20 VSA 2358. B, compensation under subsection A of the section shall be reduced by 30% for any sheriff who does not possess a law enforcement officer certification.
okay, and the question came up. If, as has happened, you lose your certification. Okay, standing tomorrow, or the day after this bill is passed.
Right.
You had level 3, but through some act of your own,
Vote.
you have, it's been revoked. You would see that 30% pay decrease.
Correct. It's not for newly elected, it's not for newly hired, I guess it should be elected in this case. It would be effective when you lost your certification.
Okay,
Well, if you elect a sheriff and the sheriff does not have level 1, 2, or 3, would they begin at that 30% reduced rate
Correct,
to begin
correct.
with? Mm,
And if you gain certification, you would get a pay bump.
Mhm.
Alternatively.
I mean, I think we decided it is, if you're gonna carry a gun and enforce the law, you should have adequate training. Or this is an independently elected official, I believe by the Constitution. But we can't set the salary level. The closer you are to what you think you should be, the more.
And I think the
pay.
opinion that we've had from council, you can't, even though perhaps some of us would have wanted to, you can't reduce it to 0.
Right,
It would be problematic.
So it's gonna be
but
reason.
30% might cut into your ability to pay your mortgage or something. Okay. Committee questions? I'm looking. Are we ready for motion?
Fun board game.
I think it's already got one from this morning. Yeah, oh, okay, we've got it printed out. Okay, unless there are more
Oh, yeah.
questions,
So we get that. Neither, I think.
I'm looking. Do you want your side by side back?
Correct.
If he bothers you, you can take it out.
There's a hornet in the room. If anybody's allergic, I can go and scoop it in a cup.
Yeah, you
Just wanted to let you know.
Maybe not allergic, but not.
Normally, leave him alone, he'll leave you alone. I think, yes,
Ready for a motion, Madam?
I am.
Okay, so I move that Senate Finance report favorably. Bill H 585. At 4.1.
585, 4.1.
Dated 5/6/24. And the timestamp is 3:35 PM.
Okay. So we have a motion to report H 585 as presented to us from, I believe it's government operations favorably. Because we have been told that it will have no negative impact on the pension, the state's pension funds or pension system.
Like that is referred
That as presented to us by, I don't know if they amended it or not.
Yes.
They did,
Yes.
okay.
But presumably the fiscal note says what the fiscal impact is in terms of dollars, it's not free.
Chris, I believe your assessment was,
It creates no impact on the state's funding obligation because the additional cost is borne by the member, not by the employer.
That's clear.
Yeah.
Mhm.
So it has no impact on the state's fiscal position because the difference is being paid by the deputy sheriffs who choose to go in or the empires. Okay, further discussion. If not, all those in favor say aye.
Aye.
Opposed say no. I'm hearing that as 7-0. Do I have a volunteer to report? I can do it. Okay, I shall report. One down.
I'm happy to whenever you want, Chair.
If you want to, okay, you can report. All right, I'm looking for. Ben hasn't come back for 6:45, but Damien is here. So Damien, we've got you on, I think, for 2. Right?
Yes.
So the floor is yours.
Great.
Well, I have 687 and.
Oh, it's in lots.
Yeah.
No, I don't have two on this one. You got 2 for here?
I do, 855 and H 867.
Okay. So
687, H 67, the alcohol bill.
Oh,
We
okay,
made time for both of everyone.
okay, so we're gonna plow through these.
867.
H 67 is the
Yeah,
first.
687 is more controversial, so, and not mine.
Yeah,
Okay,
I was a little shell shocked.
Yeah, sorry, those two numbers have been transposing because there's so much news about the other bill.
we have had so many 67s go through this committee this year that I think every number under 10 has been in front of it.
Yes. So I will start with 867, which is the alcohol bill. Would it be helpful if I throw it up on your screen?
Yes,
Okay, great.
this one is coming to us from economic development.
Yes, it is now.
You know, we did it there, I just didn't know if it made another stop,
Nope, it has not made any other stops.
okay?
So the sections in this bill that you're concerned with are first sections 1 and 2, which will have a minor impact on state revenues because we're extending the special venue serving permit. This is essentially a permit that allows a an outlet that doesn't sell alcohol to serve alcohol for an event for no charge. So there is a permit charge. Currently, it is art galleries, bookstores, public libraries, and museums,
And
and
these
this,
all started because a legislator came in with a worthy cause. I think you might have been one of them.
That was so glad. It was my great heroic contribution.
So we've added and,
And
now we're being kind of broader.
yes, now we're adding again. So we're replacing bookstore with retail establishment.
You know,
I'm sorry,
someone who sells tires or something like that, or?
Yeah,
yeah. Tires, books, clothing, sporting goods, yarn.
I will say that the chair did have some reservations about alcohol when you're trying to sell people something.
Senator Mazza had serious concerns, but
So,
was very gracious when the bill passed.
yes,
So, this is a 2-year trial. It expands it to retail establishments. One important piece is that, it excludes expressly Vermont agency liquor stores, so any 802 spirits location. And any cannabis establishment. So your Senate Economic Development Committee felt very strongly that, serving free alcohol to people while they purchase cannabis, created
an issue.
yes, there we go, that's the word I was looking for. And likewise, serving free alcohol to people at a store that sells alcohol, where it's not part of a tasting event or something like that, which is permitted separately, seems strange.
Some of us also wanted to prohibit it in the state house, but the rest of the committee didn't go along with that.
They used
I
to.
like to prohibit it while committees are in session because
It's
starting at 4:30, there tends to be a strong draw out of the committee.
Yes, so that's.
Ice cream is worse.
That's sections 1 and 2. Sections 3 and 4 are a 2-year sunset on this, so it sunsets in 2026. And there are some additional parameters added. There's a limit of 12 per year that's in place. I don't know that anyone is running up against that currently, but it does make it so you can't be doing this every day. And then it also limits the event to no more than 6 hours. So those are 2 limits that were added as part of the conversation in the House. And then, as I said, sections 3 and 4 add in a 2-year sunset. Which brings us to section 5. This will not affect revenues of the state. It allows.
Wonder why we do have this.
So this is for sampling events. And it basically is saying that when you're doing a sampling event, it's allowing you, instead of having to go directly to the manufacturer of the beverage, you can go to their wholesale dealer in the state, which makes it easier to get some of the products for a sampling event.
Okay,
Yep, so that, because otherwise you would have to, so for example, say you're a dealer of California and Vermont wines and you wanted to feature a couple of wines from each. Under the way that the existing law is, you would have to go directly to the California winery to get their wine on invoice. This allows you to do it through their wholesaler in the state.
okay,
So that's what we're getting at
all
here.
right.
It is interesting though how you think you're doing one thing. Further down the road, and what all this was about essentially was art galleries.
Oh,
Having the little glasses of white wine. and
this is a different permit. We're onto a sampling event, so this is where,
That was special thing.
yeah, so now we're on to someone who actually sells alcohol.
Oh, okay.
Where they're having an event where they're providing samplings of some of their products.
So you can go up to your local winery
Yeah,
and they can have a sampling, and I think we've allowed them to have some of somebody else's.
What wineries are under a separate permit, that's a 4th class license.
Okay, so this is,
So sampling event permits, if you'll permit me to just backtrack into the statute, because as you can tell, these do tend to run together and get confusing, so before I misspeak. Sampling event permits, enable. pull that up so I get the right language in front of me. So it is for any event that's open to the public. When you're serving a sampling of one or more of the following, and it requires an entry fee. So this is specifically like a wine with food pairing event where you would be sampling wines with different types of food, or a beer with food, etc. Versus the fourth class licenses where that allows the manufacturer to serve samples and sell their product. So that's what you see at farmers markets. And then there's also tasting events, promotional tasting events where a manufacturer comes to the bar or restaurant to provide it so that the servers can understand this wine goes well with the steak, etc. Good,
Uh-huh.
clear as mud, right?
Tucker would be
No,
proud.
actually, I remember doing the sampling at the restaurant so that you knew what you, I think that was the most recent one we did. Other than allowing you to do gift boxes and deliver them. Okay, I'm still trying to figure out why it's in finance. I
So,
suppose because it's a free.
so the, with that one doesn't apply to finance at
Any
all.
of them in here, I'm just.
So the first two, and then, I'm sorry. If I,
Did anyone get a fiscal note on this?
There is a fiscal.
There's a
note.
fiscal note.
Fiscal note, okay.
and the fiscal note is essentially that there's a negligible impact, but I let my colleague Ted Barnett speak to that. He's not in the room.
He's booked elsewhere, Madam Chair, but if you want, I could give you the 10-second version.
10 seconds is good.
All right, the fiscal note is 1 page on this. It is very brief. We expect this bill would have a negligibly positive revenue increase to the Liquor Control Enterprise Fund. The reason why you have this bill is that the special venue serving permits cost $20, special event permits cost $35. So, increasing the eligibility for these might lead to more permits being,
Okay,
purchased.
Yep, and section 6 increases the special event permits from 10 to 20 per year. So,
okay, so you can buy another,
right, and this is special event permits are basically, these are what you get if you're serving at a festival or something like that.
the garlic festival came up, there were some
Yes.
issues, yes.
Yes, Burlington Brewers Festival is the one that we always used to talk about back in the days when I was covering Title VII. In the dark ages, before we had all of this, before Ready to Drink and all of these
When
other
we were
things.
just starting with breweries and wineries, I think that was my last pass through economic
Yes.
development.
We were there together. But yes, that's essentially the impact of this
Okay.
bill for you. So
It's
it's a negligible impact.
but in the positive direction.
Yep, and then the other pieces in here are reports and an extension on the requirement for liability insurance
Okay,
by 2 years because they're still working on the details of that.
and that's another one where the cost is prohibitive and we haven't required that it's carried because it could put places out of business because of the cost, so we're still studying it.
So we go on and sure.
Yeah. They're gonna want to insure. Which is their risk, this is the bars, so they have a big incentive not to overserve.
I will say many of them do already carry this insurance, especially late night places that serve hard alcohol. But the state isn't comfortable requiring it while it is so expensive and it's hard. But many of them
We did things
are
last year
insured.
to help landlords that rent out a building. Because that is getting to be great too. So, and your bread.
Are you ready for a motion, Madam Chair?
I am, it's a committee here.
I am.
Okay.
So I would move that Senate Finance to favorably each 867. 4/26/24. And date timestamp is 9:29 AM. So we put people with 687 as amended by Senate Economic Development.
Okay, Senator Bright has moved that we report favorably based on our jurisdiction, which is that it will have possibly some positive impact on state revenue. Is there any further discussion? If not, all those in favor say aye. Aye. Opposed say no. Would a member of Economic Development like to report that?
Yeah, I'm reporting
You're
that.
reporting it,
I'm
great.
just trying to remember who's reporting.
Okay, now good. Okay. We don't have anyone voting, so 3-10. Unless.
He did have another bill.
Yeah.
Oh, page
sure.
55.
It's a big one.
This one's a big one.
Would like to get it out.
It's not on my list.
As I told you, because that was scheduled for earlier in the day before we.
Okay, then let's get H55 up. Do I have a copy?
Yes.
So H55,
Yes, and so this one,
Nice.
that's a new one, okay.
yeah, this also recently passed out of Senate Economic Development.
Why don't you all do it on Monday?
Yeah.
Yes, ma'am.
I had a meeting in the morning and I couldn't be
The
there.
date was 4/26.
So-
We've been working on this.
The impacts in this bill are primarily in the,
Before.
They're just trying to finish
Okay.
that.
Oh, we got the numbers correct.
Yeah.
Okay.
the impacts in this bill are primarily in the first couple of sections related to unemployment insurance. So I think that's why it's here. I'm happy to walk through the other sections, but also I'm aware
I
that you have
think
time.
this
constraints.
is really the bulk of it, and
Yeah,
I think just so everyone knows, this has been a compromise between legal aid and the department. So this one
Yeah.
has just been worked on for quite a while.
yeah. So the first section here is actually, this was requested by the department, and this is not part of that compromise, but I don't think it was objected to by anyone. This provides experience rating relief for employers following a natural disaster. Currently, we provide them with 4 weeks of relief from the charges for unemployment benefits paid to their employees following a disaster if the unemployment was caused by the disaster. We would be extending that to up to 10 based on experience in the past year and past several years with some of the flooding and other issues we've seen in the state.
Is this the piggyback to feds?
No, I think this is a state level piece that we control.
I believe that was in Senator McCormick's bill. After Irene, now to put this into place, just.
So
We got into trouble with the feds on that. There were limits that we couldn't do what the bill originally was gonna do because of the fed organization.
So there are things that we're extremely limited on. We do have Cameron Wood from the department sitting directly behind you, and he can comment on how their federal colleagues have felt about this. So if you'd like.
Cameron, you want to just introduce yourself? We're gonna play musical chairs here.
Very quickly, Cameron Wood, Policy and Legislative Affairs Director for the Department of Labor. We are not aware of any federal issue on this limitation here, increasing it from 4 to 10. I believe the state has pretty wide discretion in how we administer charge relief, as long as it's being done in a uniform fashion, and we're not treating certain employers in a particular way, et cetera. So we're not aware of any issues.
So section 2, 3, 4, 5, and I think 6 get into the compromise between legal aid and the department, and there's 2 pieces to this. kind of broadly that we need to think about. One is what happens when the department overpays benefits to someone. Particularly if it's not the individual's fault. So normally, the department recovers the overpaid benefits. However, what we ran into in the pandemic in particular was individuals who had received an overpayment through no fault of their own. It wasn't caused by their fraud or something else, who now needed the income, but because of the department's rules and the law, the department couldn't waive that overpayment. So they had to overpay or repay the money before they could get any unemployment insurance benefits. So the first part of this would allow the department to waive an overpayment for an individual who did not commit fraud. The overpayment wasn't their own fault, and causing them to repay the amount would be against equity and good conscience, as you see on lines 8 and 9 there on the screen. So this allows the person to request the overpayment waiver of the overpayment at any time. It also allows them to request reconsideration of that if they've been denied the waiver initially, but then their circumstances change for the worse, and they're in a situation where they think now it would be against equity and good conscience. They can request that again from the department. It also includes a provision which is time delayed, and I'm skipping over a lot of the detail here. This is delayed till July 1, 2026, or until the department's new IT system comes online, whichever is sooner, because our current ancient IT system cannot do a 50% withholding from benefits to repay an overpayment. That wasn't built into the system when it was designed in the 70s. So this is basically another piece here where, without waiving the overpayment, you can slow down the rate at which people pay it back so they get some unemployment benefits. The fourth section here is rulemaking, requiring rules on how to implement this to be proposed by November 1 of this year. And filed with the Secretary of State. And that brings us to section 5, which is the other side of this. And this is addressing individuals who are committing serious or repeat fraud against the department. So the language here gives the department the authority to prosecute fraudsters. So currently for fraud, you have to repay the benefits plus a 15% penalty. This adds the discretion to the department to also charge a up to a $5,000 administrative penalty, and also make an individual ineligible for benefits for a period of up to 5 years. So right now, ineligibility extends for up to 26 weeks of benefits, and this would be a blanket. So instead of counting weeks of benefits, you would say, for someone who, say, their second or third offense, they could have a 5-year ineligibility for benefits, plus a $5,000 fine, plus repaying the benefits, plus the additional 15% penalty. So it could be a really steep penalty to deter repeat fraud. And you have legal aid in the room as well. My understanding is that legal aid compromised on the language, but does not support the additional penalties. So and then I believe the department is okay with the language and does support the additional penalties. Yes, so there you go. And they're both here if you want to ask them questions.
And some of the discussion in committee was, there's the person that reports they're unemployed, but they're really working under the table. And they did it once because they had some bills they needed to pay or something. But then during COVID, we saw some large scale attempted fraud. I apparently applied for unemployment benefits for my 6 weeks of working in an Alaskan fish hatchery. They fortunately denied that. And when the denial letter, I caught on that something was going on, but there were a lot of identities stolen, there were a lot of, I mean, it was systemic, and that's a whole different ballgame, that's organized crime. And, so,
And I think there is still a problem with this bill, as I expressed both this year and last year, is that there aren't criminal penalties for that kind of activity in Vermont law. It's pre-pass, and again, I'll be back next year.
yeah, because then the broadcast fraud bill that kind of got looked into here.
Right.
And I think if that does get taken up, it'll go to judiciary probably separately, that's the issue, I don't wanna.
That's fine.
Criminal.
Yeah.
This is all a compromise.
Yes.
When did you work in fishing?
I guess 6 weeks, but I got tired of the snow and fit. I came back.
Yeah, so just to let you know what else is in the bill, section 6 through 11 are technical corrections for unemployment and workers' comp. Section 12 would provide workers' comp presumption that certain state employees who work in corrections, law enforcement, family services, if they develop PTSD, the presumption would be that it was caused by their work. And then that could be rebutted. But it provides a presumption so they don't have to prove the link to their work. Sections 13 and 14 are developing additional data around firefighter cancer for workers' compensation purposes. Section 15 establishes a pilot program for subsidizing annual cancer screenings for firefighters to hopefully catch cancer that's occurring among firefighters earlier.
That's on the contingency budget list.
Right. Sections 16 and 17 true up our unpaid medical leave law with the federal medical leave law. We have a discrepancy in the definitions of, our law uses the term physician instead of healthcare provider, which has been causing issues for folks who no longer have a doctor, but go to a advanced practice nurse practitioner or something like that. And then our law uses the phrase serious illness instead of serious health condition, which has caused problems for people whose family members have been in a car accident or suffered a serious injury of one form or another, and have had their leave denied when they were entitled to it. And in one case, one of the people testifying had their leave denied initially until they pointed out to their employer that they were also subject to the federal law, and the employer granted it under the federal law, which uses the term serious health condition, and this ties us to the federal law, so employers just use the same standard throughout. And then sections 18 and 19 in the bill create a baby bonds trust program pilot at the treasurer's office. It's contingent on the treasurer receiving donations to fund the pilot, so there is no state money appropriated. And then there's a report back on possible adjustments and uses for the program in the future. Is everyone familiar with what baby bonds are? Generally, I think I'm seeing nodding heads, or
They think they.
yeah. And then section 20 is the effective date. I mentioned the delayed effective date on the partial withholding on the UI benefits. Everything else is effective on July 1, except for a technical correction to workers' comp, which takes effect on passage.
Okay, and we have this because.
Of the unemployment insurance.
Was there a fiscal note done on this?
There was, Madam Chair. There is a fiscal note posted, under H55 that my colleague Pat Titterton and I worked on. We did various aspects of it. If you'd like, I could give you a quick rundown.
That would be helpful.
Sure. So, we do not expect, so it's a 5-page fiscal note, and I am not going to read every line, but I'll give you the highlights that we do not expect the, UI amendments to have major impacts. I think we say they're unknown but likely insignificant fiscal impacts. The workers' comp piece about eligibility for certain state employees with PTSD
That's what I wondered.
could increase the cost of workers' comp benefits by up to $425,000 annually, and could result in some additional attorney's fees of about $105,000 annually. We do not expect any immediate fiscal impacts in FY '25. These, I just want to be very clear that this is a range of where costs could be, but it will ultimately depend on future claims experience. Requiring the Division of Fire Safety to create the grant program to subsidize the cost of cancer screening for Vermont firefighters and enrollees in the academy. The bill does not contain an appropriation, but the big bill does. There is a $1 million contingent appropriation on the list for this initiative. It is a one-time funding source, so something for you all to consider if this is expected to be sustained moving forward. And the Baby Bond Trust Program and the Baby Bond Pilot Program, there is no appropriation. The language, its implementation is contingent upon the state treasurer certifying that they have received a donation of a sufficient amount to stand up a pilot program. But based on the universe of eligible children, we would expect that sustaining the program on an ongoing basis, on a permanent basis, should the legislature decide to do that in the future, would cost about $6.5 million a year. A funding source would need to be identified for that.
Because the original was unclaimed property,
Correct,
but that all goes into the general.
correct. And we base that on, the universe of eligible children born every year is roughly 2,100 a year. And if there's a $3,200 accounting per child, it gets you to $6.5 million.
Okay,
And there's still a major question among some of us as to whether or not the program had equity to begin with, in that it was taking only a subset of children and funding them, but the children of low-income people who were paying into the fund were not eligible to have their children participate.
right. This would be limited to children who were born under the auspices of Dr. Dunn's.
So it was based on their birth income as opposed to any objective criteria otherwise.
This was highly discussed.
I mean, it could be arguably discriminatory.
So we have a pilot program dependent on raising private funds. We have a workers. The PTSD seems to be the big one, which could result in, was it 105 annual,
And
425?
correct.
Okay, so $500,000
Up to.
up to, plus or minus. A year would be the cost,
And we don't expect an immediate term impact.
right? So it really, it'll take a while. This would be people diagnosed with PTSD, and then rather than have to prove it was job related, you would have the automatic assumption that it was job related. Let's see. And in here, baby bond. What else? Works. Station. On unemployment insurance. We don't know what that will be because. Depends on how many people, which in some ways depends on the economy. Depends on how many criminals commit fraud. And how many just people that. You'll realize that they're checking the wrong box. Okay, committee, questions, discussion.
I'd like to make a proposal, that we add the 2-year extension of the veggie sunset to this bill. Because I think if we believe that we should move that, it's safer tucked into this than it is kind of traveling below. And I don't think the rest of the language will survive anyway.
Well, we haven't even talked about it. I was planning on voting that out, but it's up to the committee if you want. That would mean we were choosing to not remake the board composition for veggie and not do the refundable forgivable loan program for small business. If that's,
I think we've run out of time.
can we get a motion to do that? That's a motion, Senator Ron Hinsdale.
Yes, I'm looking at
That
this
we
motion.
add to this
Do
bill.
where's that link?
Oh, so I asked Damien to draft it in
Okay.
I have the
preparation.
language.
Okay, that's wonderful.
I will send it to Zane and we have Rick here. In case there are questions about veggie.
I hung around.
Yeah. I used to say I need a mirror up here so I can see who's behind me, but
I was.
it's just the last week that I've had people sitting on the windowsill.
Senator is moving to amend the report sent to us from the.
Economic Development Committee to add, and let me find the language.
That on our page.
It's bills.
Damien will have,
Oh,
I just asked Damien to have it ready. I got it.
Okay,
Yeah.
so Damien,
Yep, I will pull it up on the screen.
that will be good, then we can give a hard copy to.
Yeah, and I just sent the drafts to Zane so that he can post it.
Okay.
So Senator Ron Hinsdale asked me to put in I believe a 2-year extension, correct? So
Oh, that's
this,
all.
I just want it to pass.
Okay.
Could have been 1 year, could have been
We
5
had narrowed
years,
it
but
down to 5, we had taken it off altogether. This is as good as they've been getting.
so this would extend it to January 1, 2027. And then all I did was just bump out the effective date section in the bill. And I did change the title, so now that it's extra long for your Senate Secretary to read. Miscellaneous unemployment insurance, workers' comp, and employment practices amendments, establishing the Vermont Baby Bond Trust and the Vermont Employment Growth Incentive. So it's an act relating to all of that.
Of course, he's not the assistant secretary who's gonna have to read all
Yes,
that.
I'll apologize. That's
Senator Bray,
So half the committees in economic development, I'm just trying to catch up. So it was going to sunset
Right.
and. So what's we're not, we can do it, right? There's no limitation on what can happen here, but, what's the policy reason for making the change?
we had actually taken the sunset off. It makes it very difficult for businesses to have confidence that the program's gonna continue.
Sure.
If we keep sunsetting it every 2 years, we have sunset it 2 years, 3 years. I don't know that we've ever done 5. And it's gotta have been at least 20 years.
Then it's over 2 years.
Yeah, so, but we came back from appropriations that they would like a sunset. And they put the contingency money in for the firefighters, but said that they would like a sunset. We had originally done it as 5 years. And we are not doing the new program, which was if we do it this way, there's a forgivable loan program for small under 500 or under employees, that we won't do. Okay.
the vehicle is H10, which the House passed a 1-year extension, so. This is kind of a compromise that didn't live anywhere else. We were looking at H10. But I just believe this needs to move with an actual vehicle. So this will come out of H10, that's in our.
If we get time, we can start H10 and let the sunset ride somewhere else if we want to talk.
If we want the veggie sunset extension, I would just do this personally, because anything else I think upsets a difficult balance in the last 3 days.
I mean, I'm committed to get all these bills out, so I will leave it to the committee who hasn't had a chance to hear from the veggie people. So, do you want to put it in? Okay, I'm getting yes. Am I getting 2 no's?
Well, all I know is, I mean, it's been a while, I'm in that economic development, I'm not dialed in the details of it, there's a debate back and forth, pretty much perennial as to whether it should exist at all, so
Yes,
moving the sunset out is
and we can continue
floating
for
to
2
keep it
more
going.
years.
Nobody killed it entirely. Some had it at 1 year, some had it at forever. So this is a compromise leaning far toward, we will review it again soon.
But 2 will make us, I think they're working at it. But I do think they need to become a more professional board, at least in their presentations.
We have a document from.
Sorry,
We have language.
It is draft.
yeah, so it's draft 1.1. And it's dated today at 12:56 p.m.
Okay. Do I have a motion?
So the motion would be to amend the Committee of Economic Development report until page 55 with draft 1.1, 5/10/24, 12/50.
And that adds the 2-year extension with the veggie sunset. Is there any further discussion? If not, all those in favor say aye. Opposed say no. I'm hearing that's 7-0. Senator Gray.
We also have yeah, so the underlying,
We have the underlying bill.
we have the underlying, well, we've also amended, so we have we're recommending favorably draft 7.1, page 55, as amended.
Okay.
On that finance.
So the motion is to report favorably page 55 as amended, which is just added the veggie sunset.
Jeremy down here, this is the tiny date stamp from that last piece.
I'm glad
I'm
you
looking
got
at
it.
it now.
Okay. Is there any further discussion on that one? If not, all those in favor say aye.
Aye.
Opposed say no. I'm hearing that 7-0. Okay. We got another one then.
I'm happy to report that.
Okay, that would, yeah,
Outside reporting.
Senator Rumpf is still before. Okay, 3:10, so I haven't seen Eric. Patrick is.
He was out in the hall.
Okay, we are right there, Eric.
Thanks for your time.
Thank you.
Oh, okay, we also need to vote out, while we've got Eric here, we need to vote out the trustee camping bill. Eric was here, I actually thought we had voted it out, but, it was Friday afternoon, and the senators, we did. Eric, do you know the number on that one? Not on it. It's what?
279.
279. And that's H 279.
Right.
And that was the camping bill. Remember, Eric went through it, you've got a trust and how you can set up another trust with that trust to get. And it seemed to have all the protections, and I would love a motion to approve. We could give him a break.
So here, we are only looking at the as tax levels.
Yes,
So this is a wine tasting.
no, this is not wine tasting. This is purely legal trust.
This is, we're talking about H 279.
Yes.
Just want to double check. On the basket. Present, I move the Senate. Finance report page 279.
Okay, Senator Bray has moved that we will
Pass by them.
report H 279 favorably as it was passed by the House.
Concur with it.
Did I just blink and it?
If I may,
Oh, the cam.
Eric, did Senate Judiciary have amendments at all, or did they just?
Nope.
Okay.
Straight up past the house. Yep.
Yeah, it's another one of those straight up bills. Okay, further discussion. If not, all those in favor say aye. Opposed say no. I'm hearing that is 7-0. I need a reporter. Okay, Senator Chittenden will report. Okay, we're on a roll, so Eric, you might wanna start rolling with us.
Happy to. Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. We're here to speak with the committee about, I believe, a provision in H 837, which is actually, I assume that you're on 878, right? The miscellaneous bill? Right.
Yeah, it's where I think we are, so.
Yeah, which is the judiciary miscellaneous bill, quite a lengthy bill with a lot of different sections. I believe the reason that it's in here is because of the property transfer tax connection, which is in, section. Bill in front of you, but
We have a property transfer tax in the judiciary, that's
yeah, it's related.
unusual, but
Yeah.
it's an unusual year.
Yes, it's in sections 42, 43, and 44 of the bill. I'll give you a moment of background, which is necessary to sort of understand why this tax is being implicated in the bill. So it has to do with this thing, which you may recall, called life estate deeds, enhanced life estate deeds, to be more specific, but the legislature passed a bill relating to life estate deeds back in 2020. It was Act 145. Life estate deeds are a way to transfer property in which a person doing the transfer of the property transfers upon the transferor's death. So that's what the life estate deed does. So that ordinarily, when you transfer property, the property transfer tax applies, but it applies at the time of the transfer.
Right.
In this case, and I'll just give you an example, it's most commonly done between parents and children. It doesn't have to be, but that's the most common thing.
I can deed my house to my children now and let them find it out when I die.
That's right.
But I have still, if I'm remembering and I've got the right one, I can still decide to sell the house. I can decide to paint it pink. I can pretty much do everything I can do with it now.
That's right.
But the property transfer tax, I guess originally had to be paid up front by my children, if they are the ones that are getting it.
That's exactly right.
Okay.
And that's an interest, that was what the tax department was doing, was collecting the tax at the time that the deed is created. The property, as you're saying, Senator Cummings, doesn't actually transfer until the person passes away. It's what in your example, the children are receiving at the moment that the deed is executed is what's known as a future interest. They have something, they don't have the property, they have a future interest. It's actually a law school term called a contingent future interest, because it's contingent upon some future event happening.
Am I not selling it or burning it down?
That's right. And what, in this case, what's it contingent upon? Contingent upon the person passing away. It's only when the person dies that the transfer actually happens. But in the meantime, as you said, Senator Cummings, the person you can change your mind. You don't have to even go through with it. You can say, well, I'm changing my mind, maybe there was a falling out, or maybe I decided I want to do something else with the property, whatever it may be. You can
I need the money.
You need the money instead, maybe you'd rather have a mortgage on the property and do something different. You can completely change your mind in the meantime, because the transfer hasn't fully happened because you're still alive. I think the understanding, at least from, and that legislation came through the Senate Judiciary Committee. Now, had an impact in a sense on taxation, because the tax department decided they were going to impose the property transfer tax and at the time that they created this deed, not when the person passes away. And that came to the attention of the Senate Judiciary Committee, and that's the language you have in front of you in these sections. When they observed that, they said, well, that's not the way we thought this was going to happen. That's not what we intended when we puts Act 135 in place to regulate life estate deeds. So they changed it so that the tax will not be due until the property is actually transferred, which happens when the person passes away. That's the big picture.
It can be, if it's this property,
Pardon me.
I said if it's a nice property, especially if the kids are gonna use it as a second home, given some of the other bills we've done this year. It can be a very substantial amount of money, which the heirs might not have in this time in their life. They may not have a couple thousand or, more. Or they may not have that kind of cash. And they don't have the property. So,
No, they wouldn't have it until the person
so they have,
does,
Yeah.
right? And there's a process in here for how to make, to give notice, so that what's required is that at the time of the deed execution, you have to fill out a property transfer tax return and record it in the land records along with the deed, so that there will be notice to the estate and to the children when the person does die, that, oh yeah, here's this right in the deed, and
I own a
the
house.
property's gonna be in the estate, and oh yeah, we owe this tax. And there's also a process that's established that permits someone on behalf of the recipient, whether it be the children, whoever it is, could be them, could be their attorney, if they have a probate attorney, they can ask the tax department for a statement. Hey, it's a tax been paid, or tax has to answer them, and so they'll know whether or not it's been paid. And they'll have a great incentive to pay it, because if they don't, it will be what's known as a plowed on title. You won't be able to sell the property. It's very difficult to sell it because there will be an unpaid tax. It's right there in the land records.
It will pay you. So,
Yes, if they want to sell it or transfer it anytime, they're gonna have to pay it first. Exactly. And it's interesting, there are other, those kind of deeds have been referred to as different things over the years. Sometimes they're called labor deeds, because it's sort of this legend that somehow President Johnson and Labor Johnson were the first two people to ever execute them, so they were called labor deeds for a while. Sometimes it's called the poor man's trust, because it's, the reason they're even created is because, imagine you're a family of moderate means that has only one asset, or a primary asset, it's the house, it's the only asset. It could be very costly to have to go through the probate process and hire an attorney and go and have your one asset probated. But if you use this deed, one of the primary reasons that people use the deed for estate planning is it doesn't have to go through probate. It automatically goes to the recipients, the kids or whoever.
probate takes, if it's a simple probate, it can take up to a year.
Time and money.
Time and money.
Yeah.
So, does tax have any comments on this?
I would love to make some comments.
Okay, do we have any questions for Eric at this point? Okay, what, have we got a fiscal?
Oh, you're talking about the separate piece about the,
$47 surcharge.
oh, right, another section that maybe, thank you for the reminder. So totally separate idea, step aside from life estate deed for a second.
Okay.
Now we're talking about, although I don't think this changes the actual amount of the assessment, but right now, there is whenever someone is charged with a crime or with a civil offense, there is a fee that's assessed, and a portion of that fee goes to two funds, the Crime Victim Special Fund and Domestic and Sexual Violence Victims Fund.
And we did something that messed that up, right?
Yes, last year in the bill.
Yes.
There was something that messed that up. So that's corrected in this bill as well. And the amount of the assessment that goes to those funds is not changed. The amount of the assessment is not changed. So the assessment that goes on to everybody's criminal charge, onto everybody's traffic ticket, on everything else, that stays the same. But
That
the
was
amount of
Also,
that,
one of our biggest mistakes. It's
well-
just $5, it's just $10.
now it's like 47.
Now it's 47, people can pay it.
Yeah. So now a bigger percentage of that will go to these two funds to try and shore up. You may remember over the years, those funds have been having a hard time maintaining
Yeah.
financial stability. So if we get a little bit more out of those.
Okay, who's gonna get less?
General.
I don't know, if there is a general.
Yeah, if you don't mind, Madam
No.
Chair, we do not have a fiscal note on this bill, but I did do a fiscal note on a different bill, H 880, that spoke to this very issue. What Eric mentioned is exactly right. This language that pertains to the $47 Judicial Bureau surcharge, I want to be very clear, is not a change in policy. It is a correction to be able to execute the policy that the legislature attempted to implement last year in Act 78. So the glitch, if you will, was the apportionment of the $47 was
Okay.
inadvertently made retroactive to violations issued after 2009. Turns out we can't go back administratively and
Collect things.
yeah, or change the allocation retrospectively like that. So what this language you see does is restores the old allocations in law for the legacy violations
Okay,
and makes it clear that for violations issued after June 30th, 2023, the new revenue split that you all had envisioned a year ago applies.
okay.
So this does not change the big picture with the budget. What this does, though, is make the language administratively actionable based on what you all tried to accomplish a year ago.
And we're
So-
just trying to get more money to these, not raising the fee on the tickets, but just redistributing it so that more of it goes to
Exactly,
these two.
exactly. So it used to be that the general fund received $725 out of that $47. What this language does is takes that $725 and sends it to the two special funds, $3.75 to the Victims' Compensation Special Fund and $3.50 to the Domestic and Sexual Violence Special Fund.
Okay. All right. Any questions for Eric? Do we understand how this works? We've got three, I think, bills we have voted on so far. We're on a roll. But the tax department may slow us down,
The last thing I'll
which is
mention
not a
is.
bad thing.
The last thing I'll mention is that,
So we're on Hinsdale,
Sorry.
we have the liquor bill, right? Senator Chittenden,
Do they all have amendments on them?
no,
One does.
one does.
Okay,
The, H 55 has an amendment.
okay. And the other ones are favorable? Okay, I'll be back.
Okay, any questions from Eric? You understand, we're just delaying the payment of the property transfer tax until the heirs, whoever on that life estate, life estate, is that correct?
life estate deed.
Life estate deed.
Yeah.
Because there are life estates where you can live on the property. When I was in real estate, you could live on the property, you sell it, but you have a life estate to live there until you die. So there's other kinds of life estates.
This one, these two typically allow the person to stay on the property until they pass away.
Yeah,
So they can still live.
right, but yeah, I think the one I sold, there was a house and they had built what we would now call an accessory dwelling unit. People took possession of the main house, but the people that had owned the main house had a life tenancy, I guess it was called, to live in
Right.
the accessory dwelling unit. So that was the one, but this one, it's actually the. Yeah, it's kind of a promissory.
Yeah, it doesn't come due until,
Yeah,
so.
there's no, the owner can still sell it, rent it,
Yep, mortgage it.
or do whatever. Okay,
Yep, they can revoke the entire thing. if They want to.
okay,
Uh,
just might help or not help family relationships this week.
I'll just point out the last thing is that the language itself, you understand the big picture, was also worked on in conjunction with the Bar Association for what I mentioned about it being in the title record, so that
Yes.
their notice would be given to the estate later on.
So there's notice in the land records, but when you pull the file, whoever the lawyer and the heirs, they're gonna find that this life estate had been set up. And
And it'll say the amount of tax due.
the amount of tax that is due.
Yeah.
Okay.
Yeah. And I should add this too, sorry, I should have mentioned, I'm sure tax department will probably mention this, but there is a provision in the statute that permits, because, you know, it goes to the whole question of, well, what if the person does change their mind? What if they revoke? You know, and if they had already paid the tax, right? But now they revoke, they're changing their mind, they don't want to proceed with the transfer.
Yeah.
There is a provision in statute that gives them 8 years to ask for it back. But I think that was the question that the Senate Judiciary Committee had was, well, what if you decide on, after 8 years and 1 day, that you decide to change your mind? Well, then you can't ask for the tax back anymore and you already paid it. So they decided better approach was to have it. Yeah.
Okay. Okay. Next part.
Thanks.
Thank you very much. I'm Will Baker, General Counsel for the Tax Department. Really appreciate the time today, and I hope it'll just be 5-10 minutes to add our comments regarding this topic. We did not have the opportunity to provide anything to the Judiciary Committee. So we are very happy to have this time. I have a slightly different version of events than you just heard from Ledge Counsel. The reason why the tax department assesses property transfer tax on these life estate transfers is because that's what the law requires. It's defined in the property transfer tax. A transfer includes transfers of life estates. Many years it's been in there. So that's why the tax department took that interpretation. In 2020, as Ledge Counsel mentioned, there was a codification of these life estates, which were, recognized by common law or case law before that. A codification in Vermont for these enhanced life estate transfers, which codified them in statute, added them to the statute, and also allowed for the rescission or revision of the life estate. So you could change the grantee, you could pull it back entirely, you could mortgage the property, et cetera.
So you had a life estate, which was I transferred the deed to my kid with the proviso that I live in the house until I die. And when I transferred the deed to my son owed the property transfer tax.
Or you could pay the property transfer.
Oh, I could pay.
Grantee or grant.
Oh.
I think typically it would be the grantor, someone who is probably more elder than the
Probably
grantee,
has
generally
more money.
speaking. Now, before I go on, I should also mention that what we're talking about here is, as far as the property transfer tax, is a fairly rare occasion. And that's because transfers from parent to child or child spouse and transfers from grandparents to grandchildren or grandchildren's spouse are exempt from property transfer tax. So if you give a life estate deed to your child, and there for no consideration, for no payment, there is no property transfer tax at all.
Okay.
No matter how you transfer it to them, whether it's
So what
a
about
deed or
difference?
a enhanced life estate deed. So these are, and most life estates are from parent to child or grandparent to grandchild. And so this occurrence would be, I'm transferring my property to someone else, family friend, my niece or nephew or grandniece, or grandnephew, or
The niece that doesn't know you exist, the
Yeah.
surprise inheritance.
that's when property transfer tax would be implicated. So it is a fairly rare occurrence here. And so these were codified in statute in 2020. There were questions about how the property transfer tax should be applied to these enhanced life estate deeds. And so we worked with the real estate bar, the tax department worked with the real estate bar in 2021 and 2022. And in 2022, there were amendments to the property transfer tax law to account for the enhanced life estate deeds. And it was a settlement of sorts, an agreement of sorts, a compromise. So it put a few things in the law. It made clear that enhanced life estate deeds were subject to the transfer tax. It also allowed for the refund within 8 years if the life estate deed were rescinded or
Something happened to your
revoked.
kid,
And it codified in law what the tax department had been doing for many years, which is at the time that deed is executed, the property transfer tax is not due on the fair market value of the property.
Okay.
The property transfer tax is calculated on the fair market value multiplied by an actuarial ratio that has to do with how old you are and prevailing interest rates. And that the interest rate is a rate set by the IRS
Okay.
relating to how they value life estates. So if I'm in my 70s or my 80s or 90s, the property transfer tax will be different because it's based on what the value of that interest that you're conveying to the grantee. It's not the property tax on the full value, which is what you would pay in transfer tax if I conveyed my property to you in a regular old deed.
So if I do this when I'm in my 60s and I deed it to my grandchildren, well, grandchild, it has a lower value then because it's going to be longer.
Well, no,
Or if I do it if I do it in my 80s, or it has to do with the prevailing interest rates.
no transfer tax would be due because it's your
That's
grandchild.
right, okay. The
So
kid
if you
down,
convey it to your friend,
my
it would
friend, the
be,
kid down the block that has been very helpful and mows my lawn and, yeah, all of that, okay.
it would be less if you were in your 60s than in your 90s. And also it's the value of the property at the time you execute the deed. If you execute the deed today, pay transfer tax, and then you pass away in 5 years, theoretically, these days, I'm guessing the property value will go up in the next 5 years. And so what the law as it is right now freezes in time at the time of that transfer, the value right now and the actuarial analysis, and that's the property transfer tax that you pay. So we have two concerns with this framework here. The first is just a sort of tax policy logic. That if the tax is not going to be due until the time you pass away, then perhaps the market value of the property should be taxed at that time. Not based on some actuarial analysis. Well, the way it's written right now, that would not be the case because the law relating to calculating the value is not amended by this bill. So you're still paying a less than full value property transfer tax on this transfer, even though theoretically it's not due until the time you want to clear the title.
So I'm assuming since most relatives, there's no tax due, that what we're trying to do is make it easier to transfer to someone who is not a blood relative. But what you're saying is, in doing that, we would be disrupting years of tax practice and would have an impact on the value of the property, and it could, if you go to straight market value, it would, you've got years of, sounds like just practice and then codification of that practice.
That was the compromise.
Okay,
Right now, taxes due at the time the deed is executed.
right.
And the real estate lawyers didn't particularly like that. But the compromise was the amount of taxes less because you're conveying the value of the interest that you're conveying right now as I'm executing the deed. Not when I pass away, and the possession is taken by the grantee. That is the first,
So I'm working that compromise, that's been hard fought.
that's right, it doesn't make logical sense to me that you would keep the lower property value to be taxed if the methodology now is that taxes due at the time the grantee receives
Okay.
possession of the property.
So the value to, and these are people that are not relatives, right? So it's not your children, they don't owe it. So I wanna leave it to someone who's not a relative, my best friend, whatever. Right now, they owe, or you can pay it. Somebody pays the property transfer tax based on the present value plus a calculation of interest rates now and pretty much the present value of the house. If we delay payment of the tax, logically then it should be on the present value of the house when we pay the tax, which I suppose you could come in the middle of a slump, but this one doesn't feel like it's going to slump, so the assumption is that it would cost more when you had to pay it. There's also the issue of years of common practice, now law, that we would be upending.
Well, the law as it is right now calculates the value to be taxed as the value on when the deed is transferred, reduced by an actuarial analysis. So that would continue because it's unchanged in the bill. So I'm just pointing out that
You would be paying. You'd be paying on a value that was calculated, it could be 20 years before you actually paid the tax and took possession. Which, okay.
I'm just, this is just my opinion.
Okay.
I'm not speaking on behalf of the administration or
Now,
raising taxes or lowering
this
taxes.
is tax law.
I'm just saying that
Usually
the
doesn't
logic
get
of
partisan.
it is, the logic of it is set up today so that you pay the tax on the value of what you're conveying today, not when you pass away, and there's a big
Right.
difference. That's our first concern. Our second concern is just administration. This would require whenever the grantee owner of the property.
Eric? I think tax has disrupted our role. Can you bring this concern back to judiciary?
Yes, absolutely. And if you have anything else you want me to come back in on, I just had at 4 o'clock.
No, go, I
So,
just, I think we'll sit on this and see what judiciary is thinking.
I'll pass it along to Senator Sears from the committee for sure.
Yes,
All
thank
right,
you.
You bet, thanks.
Okay,
So our second concern is purely administrative. What this proposal would require is a future owner of the property, perhaps the grantee, or if they've conveyed the property somewhere down the chain of title, to send a notarized letter to the tax department asking if the tax has been paid, and the tax department responds, yes, it's been paid, or no, it hasn't been paid, and this much is due. The proposal as it's written has the tax due at the time you execute the deed. But if you don't pay it, you can pay it later, as your alleged counsel described. I read this as interest accruing from that whole period of time. So in my opinion, the now owner of the property is not going to be very happy about paying all that interest. And probably is not going to be happy about having to send a notarized letter to the tax department asking for lien payoff and having the tax department have to consider it and then respond. There's a lot of administrative work injected into the process here that is very similar to our old current use lien. I don't know
Don't need
if
to say that.
you all remember that, the current use
I
subordination
think that was
process.
even before my time, but.
And very similar to the land gains lien, where you have to build within 2 or 3 years and then check back to see if the tax is
How
paid.
many improvements you put on the, yeah.
Exactly, these are the two, other than collecting tax itself, these are the two most detested processes that people complain about the tax department. So I'd be remiss if I didn't point out that what we're doing here is adding another one of those, and you've heard
Okay,
Commissioner
so you're
Molly.
going to inherit in year one. But you're not going to take possession. And you're not going to owe the tax until year 10 or 20 or 5. In theory, the house is accruing in value. So you're saying you think interest would be owed on
Well,
taxes for,
my point is that the bill,
yeah,
the bill says, on page 48, that at the time you execute the deed and report it, the amount of completed property transfer tax return, knowing the amount of tax due to the department shall be recorded. Then it says no tax shall be due until the person passes away.
okay, so.
And then later
I'm
on-
going to okay, so the tax would be assessed when you do the life tenants, the life estate.
That's right.
deed. The tax would be assessed, it wouldn't be due. Under normal process, you are paying interest on that owed tax for what could be quite a few years, maybe it's only 1 or 2. But at some point, you're gonna take possession of the house.
And you don't,
Hopefully, unless somebody sells it, unless the original owner sells it, burns it down, whatever. So, yeah, it's,
Unless you
so-
outlive the person who's.
well,
who-
your deed, there's always that.
but
But
the,
the tax would normally accrue interest, so unless we change that. Because we're just saying it's owed, but you don't pay it. Unless we change that. There would be a significant amount more than the tax. On the other hand, when you take possession, in theory, that house in normal real estate markets. Would be worth more 10 years from now than it is now. Barring the owner letting it deteriorate or burn it down or whatever. Okay, I think we have a lot to mull on with this. I'm hoping that we will get some communications. And this would only help people who are not blood relatives. So since most people leave their homes to their kids or grandkids or their parents or something, this would hit transfer to someone who's not. Okay. This one, we will sit on for a little while.
I'm sorry to slow you down.
That is fine, we're gonna go back and roll. So this one is on hold. And, oh, we're only a half hour behind. We will have to take a break at 4:30 because I told people that have amendments to the yield bill to come in. I've only heard of one person coming, so, but there may be more. But we'll go to that and then we'll see if we can finish up our bills in short order. Okay,
Quick question, so are you going to judiciary as well? Or is this a?
We haven't been invited, we're in good citizens, go and explain what I've explained. Here
okay,
to that committee.
yeah, I hope that they won't have you in this. We have listened. I don't know what we're gonna do, if anything, but it's just, but it would be better if there could be some discussion with judiciary and see if we can't work something out. Because I think this was a unanimous vote, but they didn't hear from the tax department, which is new information. Okay, Committee, we're gonna go on. Oh, and one of my favorite things, we're going on to H 233, enacting the licensure and regulation of pharmacy benefit managers. Jen is here, and then we have a Sam Hallmeyer from State Affairs Pharmaceutical Care Management. I've also been told that CVS has a pharmacy benefit manager and they have some concerns, so let's start at the beginning and see what the bill does.
All right, good afternoon, Jen Carter from the Office of Legislative Counsel. I don't know if you want me to put it up or you
I
all
think
have.
that would help because if anyone is watching, there seems to be interest in this bill.
Okay.
Mr. Hallmeyer is with us on the screen. So we will hear from him after Jen and us. Jen is right.
Just a quick question for Ms. Covey. So are we looking at the Anthony House?
You are looking at the Ants Past House, and there is a small amendment from the Health and Welfare Committee. Review bill you're looking at, and certainly part has fees in it from the House. Oh, thank you. Thank you.
Okay, because we aren't the Health and Welfare Committee. And we don't know that any of us have served on it. 30 seconds on what is the pharmacy benefit manager can do. Sure, it would be helpful to know who you are regularly.
Yes, it's a member of I said it or not, so Jen Carter in the Office of Legislative Counsel. A pharmacy benefit manager is an entity that manages the prescription drug benefits of a health insurance plan, typically on behalf of either a health insurer that contracts with them, or for a self-funded plan. They may also contract with a pharmacy benefit manager. But the range of services can run from just administering claims to administering claims, setting the formulary for what drugs are covered under the plan, negotiating with the manufacturers on prices, paying the pharmacists for the claims paid out, and in some cases, charging the insured depending on the structure of the contract. So basically the idea though is that it's the pharmacy benefit manager is the entity managing the pharmacy benefit under some kind of health plan.
They frequently negotiate, at least when they started, they were negotiating prices. Part of the deal is they could get you a better price.
Right, they're often doing volume-based negotiations with the manufacturers and negotiating rebates to save money for the health insurance plan.
Their average wholesale price, which is what things are supposed to be based on, was
Mhm.
fondly called ain't what's paid.
Right, and lots of acronyms in health,
And a lot
in that
very
prescription drugs.
foggy areas.
Yes. So the broad overview of what this bill does.
Well, it's like track, where we have the underlying bills, and we also have the amendment from health and welfare.
Yes.
So we're looking at,
The health and welfare amendment is yes, but the health and welfare amendment is very specific and a piece about the information that the Office of the Healthcare Advocate can get from the Department of Financial Regulation as
Okay,
part of
so
the licensure.
we should go through the bill and then we'll get.
Right, I can tell you when we get to that piece.
They have basically given their stamp of approval to most of the bill.
Right, but the changes is quite narrow, and as I understand it, was responding to some concerns that were raised, and the healthcare advocate proposed some alternative language that seemed to make people more comfortable. Okay, so as the title says, is H 233 an act relating to licensure and regulation of pharmacy benefit managers. We do have a number of PBM, I'm gonna say PBM for the most part, number of PBM provisions in our existing statutes. They are in a few different places, so a lot of what looks like new language here is not actually new to the statute. It's just being combined into a single PBM chapter that also includes licensure in a way we have not done before. It starts out with the purpose. The purpose of the chapter is to establish standards and criteria for licensure and regulation of PBMs, providing claims processing services and other prescription drug or device services for health benefit plans. Talks about how it's doing that, including protecting public health, safety and welfare, promoting solvency of the commercial health insurance industry, providing for powers and duties for the commissioner of DFR, and prescribing penalties and fines for violations. Goes through a number of definitions. Most of the definitions are the same as an existing law, except again, consolidated into a single chapter instead of spread out kind of piecemeal across a few different subchapters and chapters. So I won't go through these, except maybe to stop at the definition of pharmacy benefit management. So pharmacy benefit manager is somebody who's performing pharmacy benefit management services. Pharmacy benefit management is an arrangement for the procurement of prescription drugs at a negotiated rate for dispensation within the state to beneficiaries, the administration or management of prescription drug benefits provided by a health benefit plan for the benefit of beneficiaries, or any of the following services provided with regard to the administration of pharmacy benefits: mail service pharmacy, claims processing, retail network management, and payment of claims to pharmacies for drugs dispensed to beneficiaries, clinical formulary management and development and management services, rebate contracting and administration, certain patient compliance, therapeutic intervention and generic substitution programs, and disease or chronic care management programs. And then pharmacy benefit manager is somebody who provides those services. We're typically talking, there are 3 PBMs that have, I think 80 or 90% of the market share of the country. And then a number of smaller ones, but there are 3 big ones we're often talking about when we talk about pharmacy benefit managers. One says who it's not. So directs DFR to do rulemaking. They have existing rulemaking authority, but this has some additional provisions, including that PBMs file their advertising and solicitation materials with DFR for approval before sending them out. And requires DFR to report annually to this committee and others regarding PBM's compliance with this chapter. Subchapter 2 is the licensure. It requires, this is a new requirement, the person not establish or operate as a PBM in this state without first obtaining a license from DFR, from the Commissioner of Financial Regulation. We currently have a registration process where PBMs are required to tell DFR, I think they carve some of that out to the Vermont Care Board, but in statute it's DFR that they're doing pharmacy benefit management work in this state, but there's not a licensure requirement. Here's the fee, and this is,
We have it.
yes, this is coming to you specifically, I know for this piece. There was a different fee as introduced and as passed the healthcare committee. It was changed in finance based on some changes in assumptions. The idea being that the fees would be sufficient to pay for the positions that are created to regulate the PBMs.
Okay.
So as it comes to you, it requires someone applying for a PBM license to include with their application a non-refundable application fee of $1,600 and an initial licensure fee of $10,000. And then on the next page, you'll see there is an annual license renewal fee of $12,000. So first year would be $1,600 plus the $10,000 initial licensure fee, followed by an annual renewal fee of $12,000. I think there's potentially going to be some additional work happening on this outside the room, so I don't know if there are any other proposals at this point.
Okay. And Ways and Means has worked on this.
Ways and Means put in these fees.
Numbers. Okay.
Right.
And if we, it's were there any calculations or
If Nolan is
no one, you have
to
calculated?
talk to you about,
Okay, so when Jen's done, you can, this is really our space, so I'll have you up and you can tell us how we got into those numbers. Okay.
so then it goes through a list of prohibited practices, for PBMs. Most of these are the same as in current law. They relate to things like banning limits on what pharmacies can say to patients, tell patients about the drugs or their costs.
Big one
Oh,
was
gag
you could buy
clauses.
a generic cheaper than you're gonna get it.
Or you can pay cash, you can pay out of pocket, that would be cheaper than going through your insurance.
It was
And-
gag laws.
Right, so we already had those, we're putting them in here as well, they had been expanded a couple of years ago in work that the legislature here did. It also sets limits on what patients have to pay for out of pocket for prescription drugs. Again, similar to what's in existing law. However, there is some new language on copay accumulator that requires, let's see where this is. This is on page 10 of the as passed by House. This requires a PBM to attribute any amount paid by or on behalf of the covered person, including any third-party payment, financial assistance, discount, coupon, or other reduction in out-of-pocket expenses made by or on their behalf for prescription drugs. Tells the PBM to attribute any of those amounts toward the out-of-pocket limits for prescription drug costs under Vermont law, the covered person's deductible if they have one, and to the extent we're allowed under federal law, the annual out-of-pocket maximums applicable to the covered person's health plan.
Okay.
And then there are some carve-outs that copay accumulator language does not apply. Shall only apply to a prescription drug for which there is no generic or interchangeable biological product. So if there's a generic and the person gets the brand name with a coupon, they don't get the benefit of that copay accumulator.
So
Or for some other reasons, and we have a carve out for
all
all
the
that.
celebrities that are getting up there in age are now telling you to look on your phone and get a coupon, or you're getting it, Martin Sheen does it. Martin Short does it, everybody. You go to the pharmacy, you look up on your phone and you get a coupon, or you get a lower cost, I assume that's a coupon. What this is saying is, I go in and there's no generic, I'm getting one of those really expensive name brand drugs, $200 a pill. And I got a 3-month supply. I have a 10% copay, I don't know, I've got $1,000 copay on this bill, now that would be, I've got $100 copay. They have to count you towards that copay. Any coupons, is this meant to reduce my copay?
This is meant to help you get to your out of pocket, to your cap faster.
Oh, okay. Since I've got to pay the first $1,000 in my prescription cost, is that right?
Well, so that would be helping you get towards your deductible if the additional amount of the coupon was counted toward the amount that you had paid out of pocket.
Okay.
So it's attributing coupons.
It's either using other sources other than cash I take out of my pocket. If I get a coupon, if I get, some kind of a discount, all of that is credited, even though it's not cash I paid, it's credited towards my deductible or my out of pocket.
Right, it's getting counted towards your deductible and out of pocket.
Okay. So
But only if there wasn't a generic available, you can't
Right.
decline the generic and go for the more expensive one, unless you've been on step therapy and those ones other levels hadn't worked. And
this
there
is
is,
just meant to, if at all possible, to try and help me buy down what I have to come up with. Right away, either deductibles or payment out of pocket. I'm responsible for the first X $100 or X $1,000, whatever.
Right.
Okay,
Right, so it's counting anything that is paid on your, by you personally or on your behalf. For the out-of-pocket requirement goes toward your out-of-pocket, whether it's deductible
so
or.
my daughter
out-of-pocket
pays for
expense.
half the thing. That
It's
comes,
paid on your behalf.
it's paid on my
That would be
behalf,
the-
then I'm paid.
on-
Okay.
All right, and then also notably at the bottom of page 11 is a ban on spread pricing. Spread pricing is the practice in which the pharmacy benefit manager, the PBM, reimburses the pharmacy for dispensing the drug to you less than what they bill the insurer for having paid for the drug for you, and they keep the difference. So they bill the insurer more than they pay the pharmacy. They keep what's called the spread,
Yeah,
which can be a very small amount on a per prescription basis, but on some of the volume, it can be quite large. And so this would prohibit PBMs from conducting or participating in spread pricing in this state, which means that a PBM must ensure that the total amount required to be paid by the health benefit plan and the covered person for the prescription drug, so that the insurer in the out-of-pocket does not exceed the amount that the pharmacy paid, amount paid to the pharmacy for dispensing the drug. We sort of define spread pricing.
Okay. so. I'm assuming that might be a good part of their income.
It is certainly the way a number of PBM contracts are structured. There are other ways that they are structured. That's.
Yeah, if you're billing the insurance company more than you're actually paid. And you have no contract with the insurance company to be their PBM, or maybe you do, and they're paying you to be their pharmacy benefit manager, but then you're taking the spread too. Okay, so this says, no, you can't, we'll wait and see where it pops up next.
So then we have an enforcement provision. And this is where the language change from the Senate Health and Welfare Committee comes in. So it requires DFR to enforce compliance and allows DFR to examine or audit the books and records of a PBM to determine compliance. And gives protections around that information or data exempt from the Public Records Act, not subject to subpoena, not subject to discovery or admissible in evidence in any private civil action. And then it gives the Office of the Healthcare Advocate the right to receive or review copies of materials. The Senate Health and Welfare version narrows the scope of what the Office of the Healthcare Advocate would have access to. So we can look at that in a minute. But that replaces this provision here. And then there is also language in here giving a private right of action to a pharmacist, pharmacy, or other person injured by a PBM's violation of the chapter.
That's interesting.
Section 3614 says we're intending to comply with federal law. Nothing should be construed to conflict with applicable federal law. Section 3615 allows DFR to bill back its reasonable expenses to the regulated entities. Subchapter 3 is deals with pharmacy benefit manager relations with health insurers, and it allows insurers to audit PBM activities. This is the same as in current law. It requires PBMs to allow insurers with certain types of PBM contracts to access information that they need to audit.
Can you go back to the private right of action? Is it is it just referencing the Consumer Protection Act and saying you have?
It doesn't specifically reference the Consumer Protection Act. DFR has enforcement authority, and then it also gives a private right of action to any individual who's been injured.
It says individual of pharmacy, sorry, I don't have my glasses.
Oh, it says a pharmacy, pharmacist, or other person injured by a pharmacy benefit manager's violation of this chapter may bring an action in Superior Court against the PBM for injunctive relief, compensatory and punitive damages, costs and reasonable attorney's fees, and other appropriate relief.
Either of that needs to go to judiciary or economic development, but I think this private right of action conversation has gotten a little out of hand, especially because it's not even referencing the Consumer Protection Act. Anybody has a private right of action in order to be able to seek redress for a situation, but I don't know
I'm not sure
why.
that's necessarily true.
Well, how would this play out? I mean, how would this work? That is different than the access to the court of law.
Okay. We've got Sebastian on the line for the next one. Our jurisdiction in here are the fees. If we have questions about the other things and want to do amendments, I think we need to take them to health and welfare, because there is no way we can go over this bill and rewrite it at this point.
I'll just alert judiciary.
That is a private right of action, and I think that we can deal with. Well, we can go back and ask the welfare to look at it. Okay. Can we just move through this?
All right,
I
so.
want to get Nolan to tell us why we need those fees to enforce this.
All right, so we have the insurer audit of PBM activities, we have PBM required practices with respect to health insurers. Again, most is the same as current law, including the requirement that that the PBM act in in insurer's best interest, has a fiduciary duty to the insurer client. The bill does.
Is that, no, that isn't in present law.
That is in current law. This is part of what was added 2 years ago, I think, in Act 131. The next group of sections deal with PBM PBM relations with pharmacies and required practices with respect to pharmacies. Again, most is the same as current law, requiring prompt payment of claims, same reimbursements for non-affiliated pharmacies as for PBM affiliates, provides some protections for 340B covered entities and their patients. The only difference from current law is there's just a specific exemption or carve out of Medicaid from the 340B language, just because their relationship is so different with 340B. Section 2 amends an existing statute. So now we've left the new chapter. Section 2 is amending an existing statute in Title 8 on insurance practices that prohibits anyone from doing business in this state, including also any insurance agent or broker, from using in connection with the solicitation of health insurance, and this would add or pharmacy benefit management, any advertising, copy, or practice or plan of solicitation that is materially misleading or deceptive. So it's adding PBMs to this existing ban on misleading advertising practices. Section 3 makes some changes in 8 BSA 4089J, which is a statute in the health insurance chapter on filling of prescriptions with retail pharmacies. It adds a definition of direct solicitation that comes up later in this section. It has similar copay accumulator language, again, requiring that the amounts paid by or on behalf of the patient must get counted toward their out-of-pocket, and deductible requirements with the same carve-outs for generics and high deductible plans. It directs health insurers and PBMs to adhere to definitions and requirements and guidance around pharmacies and pharmacists that are set by state and federal law and the Vermont Board of Pharmacy, and not add additional regulation or classifications or distinctions among drugs that exceed what if we have in state and federal law. And then it has provisions about not making direct solicitation to the beneficiary of a health insurance plan unless certain conditions apply, like the beneficiary is given permission, or they're following up after having furnished something to the patient, things like that. And then E says that a health insurer or PBM shall not alter a patient's prescription drug order or their chosen pharmacy without the patient's consent. And then it clarifies this is not meant to interfere with the generic substitution requirement. That is still a requirement on the pharmacist, but the insurer and PBM should not be making changes to what the patient was prescribed or where they choose to built-in prescription.
Okay.
Sections 4 and 5 kind of get into how to apply these, so we repeal on July 1st, 2029, the existing PBM provisions, and there's that long period in there. Because we have contracts that are already in place that won't be affected by these changes. So working with the FR, we've gone out some period of time and said, to the extent that any provision of existing law conflicts with those provisions, with these new provisions prior to that date, the new provisions will. Then we have some applicability provisions around with provisions of start applying when. Trying to, again, deal with existing contracts and not making any changes to those, and getting time to come into compliance.
Okay.
We create 3 new positions at DFR to do this enforcement, PBM enforcement, and appropriate 405,000 from to DFR from its insurance regulatory and supervision fund in FY 25. And to
And
expect
this
July
is
1st.
essentially what those fees will pay for.
Exactly.
Okay. Committee questions. Okay.
And then if you're interested, the amendment from,
Just gonna say, I always still have.
Yep, so,
For money.
the amendment, if you remember, there was language in the enforcement section where DFR can get access to all kinds of information and gave Office of the Healthcare Advocate access to everything. This limits it and just gives them the right to receive in full a preliminary report of any examination conducted by DFR, the PBM submissions or rebuttals to the report, the final report, and the commissioner's order adopting the report. And directs the Office of the Healthcare Advocate not to further disclose and protecting the information from discovery or speed.
Okay. Senator Bray, you had a question?
No, I just, thought, well,
Wanted to
before
see
we
that.
moved on,
Oh.
well, we had new council.
Oh, and I didn't read that.
Debate, yeah.
Okay. I think Nolan, can you?
There is the language if you're interested.
So we are looking basically at the section with fees. And there's a application and then an initial license fee and then a renewal fee. So it's 106 and 110
$1,600,
to start and then 10,000.
right, $1,600 to
Initial
start, 10,000 and then.
All of those do.
Yes.
Renewal.
And Nolan Brown has us all on against that, sure.
Okay.
Hi,
Hi.
for the record.
You've been here a lot this year.
I know, and I wasn't even planning to be here today.
Ooh.
Spoken to somebody, said, oh, you're doing this, maybe that's.
Everybody should plan to be here for the rest of the week.
Well, I didn't hear, I didn't ever doing any of my bills, so.
Yeah, so we're doing them all.
All right, so I'm gonna share my screen, I assume I'm ready. Okay. So you have the fiscal note, so I'm gonna work it a little backwards here. So as Jen pointed out, fiscal year costs are 406,000, that's for the people at DFR to do the work. And then fiscal year 26, it's a 420,000, we were building in pay act. Assumptions around pay act. So, what happens is that this fund is, generally DFR is paid for through the insurance regulatory fund. But that's one of those funds that gets swept, so it brings in way more money than they use, so it gets swept, so whatever's left in that fund is accounted for when you're budgeting, so. Even though there's
It's
plenty
going to
of,
go into the general fund.
yeah, so even though there's plenty of money in the fund to technically cover it, you've already counted for those dollars elsewhere.
Right.
Hence, and also there was also a sense that like generally DFR, the idea is that your fees would pay for the work and the regulatory of that particular profession. The problem we run into is that it was unclear how many there were. It's estimated there's between 30, what did I say, it was 30 and 40 entities, PBM, people that would be charged, organizations that would be charged. But if you're trying to cover $406,000 from 30 to 40 people, you can average of 35. To get there, you need, it's 1,600, you're playing with the numbers, and the licensure fee was $10,000. And it's $12,000 down the road because you're not getting that application fee, which is a one-time and your building and the payout increases. So that's how those numbers were derived. It was, they wanted to cover the, Ways and Means wanted to cover the cost of regulating this new entity through the fees, like, paid for. That's why they're so high.
Okay. And, but they cover the cost of regulating. We're assuming the PBMs are making money. They may make less after some of these, especially the ones on the spread.
The question that came up, and I don't know, maybe the reps could mention that, was what PBMs pay in other states that might be regulated, or how high this is of fee relative to what other states are doing. I don't recall those. Maybe
All right.
the reps would recall that.
Anybody know other state you do?
Maybe I'll phone a friend here.
You want to phone a friend and just tell us your name and you know the routine.
Sure, Madam Chair, Representative Cordis from Lincoln, I'm the sponsor of H 233. Our committee, House Healthcare, went back and forth with DFR early on in the session about these licensing fees. Originally, the licensing fees was in the hundreds of dollars. But again, the issue was covering the cost of those 3 positions. Also, part of the problem, as Nolan mentioned, VCures lists all of the entities, the companies that are registered in Vermont that perform PBM services, and there's about 300 of them. So it took quite a couple of months going back and forth with DFR to figure out if all of those entities would be required to pay a licensing fee. And then toward the end of the time in our committee, it landed on 30 to 40 entities. Other states, New York charges $24,000 for 3 years. So that's $8,000 a year. Minnesota, $8,500 a year for licensing fees. There are only, I think, about 10 states so far, although it's growing because this is such a big issue.
Yeah.
That are more states are now putting PBM laws on the books, so we'll probably see more licensure activity in other states, but that's
other states may have more PBMs active. Bottom line is, this is what, to our best estimate, it's going to cost us to regulate them. We may find out we only need 2 positions, or we may find out we need 6. But
DFR was pretty clear about the 3 positions of what they thought they would need to regulate this.
okay, any questions for Noel?
There seems to be a difference between regulating 40 or so and having something like 300 identified. Is there some number that doesn't require the license? And why would we have such a variance?
It was, well, I think it was how it's coded in VCures, right? So
Okay.
VCures, when you look up certain things, VCures is the claims database that Vermont Care Board has that looks at claims data for all the different entities. And so when it was looked at to determine, when you type in a code of PBM or whatever, a lot of things pop up, but then as they started narrowing it down, like, well, these are actually the ones that fall into the bucket that are regulated by this particular legislation. But it took us, the Representative Cordis talked about for DFR and us to sort of get to a place like, oh no, actually, these are the folks that fall into this bucket. Those other ones, they, for various reasons, I would let Sebastian talk more about that if he testifies. Otherwise, it was just the ones that
Sebastian's
felt
actually
were,
coming in on the next bill, but
okay.
we're gonna have to take a break from bills at 4:45. That's when Zane has scheduled the amendments for the yield bill. So we'll see who comes in on that, and then we'll go back and see if we can get the next one out. And we've got 2 more.
Okay, because I have to leave at 5 also, and
Okay.
6:22 is one of my little 2, and I'm not on the agenda, but.
Okay. So, okay, so we can figure, I think we can move on. I've got Mr.
You want me to just do it?
I've got Mr. Hallmeyer to testify, and then we can, I would be very happy to move this bill. So, Mr. Hallmeyer, are you with us? Yes, you are.
Yes, Madam
Well-
Chair, I am here.
Welcome to Senate Finance. We just ask you to introduce yourself for the record and who you represent, and then the floor is yours.
Thank you, Madam Chair and members of the committee. For the record, my name is Sam Hollmeyer with PCMA. PCMA is the National Trade Association for America's Pharmacy Benefit Managers. And PBMs administer prescription drug plans and benefits for millions of Americans with health coverage provided through large and small employers. I did submit my written comments today to the committee, so we'll keep this verbal testimony brief because I know you have a lot on your agenda, but I am here in opposition to House Bill 233. So I want to start off, and you discussed it a little bit, was the private right of action. We're concerned about this. This is section 3613 of the bill. We are worried that it would encourage pharmacies who potentially are market competitors of PBMs to file lawsuits aimed at disrupting the business operations of payers and the normal contracting processes between PBMs and those pharmacies in Vermont. And we think it's going to result in higher premiums and higher costs for Vermonters. And we feel that this should just be left to the normal judicial process. And I think that was mentioned earlier. But we're not aware of any other industry or process like this in Vermont that has a private right of action, such as the one laid out in this bill. So therefore, we respectfully request that you strike the language of section 3613. Next, we do want to discuss the ban on spread pricing as well. This is in section 3612, sub lowercase f. PBMs offer payer clients a variety of contractual options to pay for those PBM services. One of those is a pass-through model, and the other one is spread pricing. But we feel that they should be able to choose that option that is best for them based on the services that they need from their PBM. I think there's a misconception that payment to in a spread pricing arrangement, that it is always that, the payment to the pharmacy is always less than what we charge health plans. We don't find that to be true. This is a risk mitigation model for where plans have a better understanding of what they are going to pay. And the payments between us and PBMs and pharmacies and the payments between health plans and pharmacies do vary. But I think I want to address that there's a misconception that, it's always less and the PBM is always in the green there. Many clients, do choose a spread pricing arrangement, like I said, because it achieves a pricing level guarantee. It's a little bit more predictable, to sum it up. So finally, we ask that you strike section 3612 subparagraph F. And it was mentioned previously that, Act 131 did pass, I think it was believed 2 sessions ago, and we're still feeling the consequences of that and we feel higher costs. And we're concerned that House Bill 233 will add additional costs and create unintentional consequences, such as a private right of action and a ban on spread pricing. And therefore, we request that we're opposed and vote no on House Bill 233. I appreciate the time today. I know you all are really busy, but I'm happy to answer any questions you have at this time.
Okay, are there any questions? I'm not seeing any. Thank you.
Thank you.
Committee. Our area of jurisdiction are the fees. I know there's concern about the private right of action. I have some concern about if we do strike the spread, where they'll make, where they'll go to make their profit, but they're gonna make their profit. They're out of our jurisdiction. Any member of this committee or all members of this committee could do a floor amendment on the private right of action, or we could try. I know this is the second private right of action that Health and Welfare has put on a bill this year, one against the vote of the Economic Development Committee. So, but that's, if we start undoing the work of another committee, we're not going, yeah.
They should have
Will
to
yell at us
send
and Ashley will send me a nasty note. As I do what I'm told. Okay,
I think I'm reading the room to say I'm ready to make a motion. I would move that we vote favorably H 233 as amended by the Senate Health and Welfare Committee, draft 1.2 dated 4/18/24 at 10:48 a.m.
okay. Senator Chittenden has moved that we report H 233 favorably. We are only looking at our sections, no judgment on the rest of the bill.
So as it came out of Health and Welfare District Review, that includes the private right of action,
Yes,
and that was added by.
I'm not sure, no, it was not added. It must have come out of the House with that in. Okay, so I understand the concern, but,
No, I would love to be off the hook on this.
okay.
Just say it's not our.
Right, and also say, because it doesn't even reference the Consumer Protection Act, it's solely judiciary authority that it's like an unfunded mandate to the court. It
Okay,
just,
so we will,
that we can deal with it.
we can deal with
Yeah.
alone or as a group of, but it's not in the jurisdiction of this committee, and if we start picking this bill apart, we're gonna make a mess, because we don't have any background on it.
Are you ready for a motion?
I
No,
need
no.
you to.
You do the draft 1.2.
Yes, you did, and the time, and the date
I
stamp.
wrote it all out. but it doesn't-
You've been replaced.
Okay, so I have a motion
Oh,
to
you put on the
approve.
photo.
That's what I used to do.
Okay, I have a motion to approve.
Oh, my.
Are we ready for a vote? Any further questions? If not, all those in favor say aye.
Aye.
Opposed say no. I think I'm hearing that. Am I hearing it 7-0 or 6-1?
Probably 7-0,
Probably
with
7.
great reluctance
I know.
and concern.
It's a very complex section. Okay. Maybe we'll see if there's any amendments out there. I know Senator Wood said she would be down. So we're gonna take a 15-minute break from doing bills. Oh, report. I will report that. Since I know the PDMs are,
If,
maybe in better shape to ask questions.
I can tell.
if 622 is an easy bill, Jennifer Carvey's here. and
Yeah,
so
we're
is-
gonna go. So Jen, can you walk, what is 622, and we have, Sebastian Aguego, and I think there is one concern about. I don't know what it is. Oops, okay. So we will go. We should get through this, and then. No, we're not gonna finish on time, but we started an hour late, so. We'll roll it, okay.
All right, again, Jen Carvey from the Office of Legislative Counsel. So in this case, we are looking at each 622 as passed by the House and has a couple of amendments from your colleagues. But most of it is as passed by the House. So this is on emergency medical services. It starts out by amending the statute, amending the chapter or beginning of the chapter on emergency medical services in Title 18 to add purpose and some findings. Section 2 deals with the emergency medical services special fund, so this is maybe part of where you come in. This is, we're dealing with how the funds are used. So under the existing law, the Commissioner of Health administers the fund to support training programs, data collection and analysis, and other training issues, and delivery of emergency medical services and ambulance services in Vermont. The new language directs the Commissioner to prioritize the use of funds to provide grants to programs that offer basic emergency medical services training at low or no cost to participants. And also directs the Commissioner to make reasonable efforts to award grants in a way that supports geographic equity among the EMS districts and provide technical assistance to districts to ensure that grants are available to support EMS training in districts that have historically had problems getting grants from the fund.
So we have this probably because.
No, you don't get to more fun
Get to
stuff, you
more
get to
stuff.
actual money.
Oh,
Happening.
real money, okay.
Yes. This next piece, it costs money, but it's not why it came to you, I don't think. Section 3 amends the Medicaid statutes to add a requirement on reimbursement for, emergency medical services delivered without transport. When services are delivered to a Medicaid beneficiary who is not transported to a different location.
Okay,
Only
but they
barely
come to your
recently-
house. They get, you
Treat you,
don't
and
need
provide
to-
you some
yeah.
services, but you don't need to go to the hospital, treatment without transport. That has only fairly recently been reimbursed all under Medicaid and is not being reimbursed at a level that is, equal to the Medicare basic life support rate, so this would direct that reimbursement to be an amount equal to the Medicare basic life support rate. You'll see later
I
that
assume that would be coming out of the state share of the
it's federal match, I mean, it's state federal match, so the total amount you'll see later on is 74,000. Some of that is state, some of that is federal. You'll see
and
the
that's money that would reimburse the EMT services.
Exactly.
Okay.
And then annually, as part of its budget, AHS is supposed to report the amount of additional funds that would be necessary to reimburse EMS providers at a level equal to, and then this is where the Senate Health and Welfare Amendment comes in, level equal to the Medicare rate for the emergency medical services delivered. So not necessarily basic life support rate when it's
So
not
they
basic life
come
support
and
services.
they treat me and I'm eligible for Medicare. And at the same time, they treat my grandson, who's on Medicaid, they get paid a different rate. Depending on,
Yes, currently Medicare pays more than Medicaid, as is often the case. But in this area, it's asking AHS to come back with information on what it would cost to be reimbursing Medicaid at Medicare rates.
so I'm not spending anything yet.
Not on that piece, right? The treatment without transport does spend.
We raise, so we gotta raise money somewhere.
Section 4 is just a kind of a cross-reference into an existing statute on reimbursement for ambulance service providers that says for Medicaid, look over at that statute in section 3. Section 5,
Medicaid still, or is it Medicare? I remember when I was dealing with the local ambulance, that you take their payment and you can't bill the patient for the difference between your cost.
right,
You
there are
can bill the patient for the whole thing, but if you take their payment, that's it.
I believe balance billing is prohibited under both Medicaid and Medicare.
Yeah, that's what I thought, and the ambulances
This
were,
doesn't change that.
yeah, and they were coming up pretty short in some.
All right, section 5 makes some changes to the EMS Advisory Council. Some of it is just kind of cleanup and updating language. Doesn't change anything about the membership, although earlier versions had. Specifies that the EMS Advisory Committee gets assistance from the Agency of Human Services. And then it replaces an existing annual report that the EMS Advisory Committee does on the EMS system to various committees. They've been doing the same reporting the same information for several years, and they said, we feel like we've told you this enough. It's the same thing every time, so this was changed up. Instead to be, to have the EMS Advisory Committee develop and maintain a 5-year statewide plan for the coordinated delivery of EMS services in Vermont, including specific things and updating the plan at least annually. And then has that delivered annually on or before December 15th to the Commissioner of Health and the General Assembly, reviewing progress for the 5-year plan and goals set by the committee for the coming year. Section 6 tasks the EMS Advisory Committee with doing some work. 2 things. One is collecting data necessary to conduct a complete inventory and assessment of the EMS services currently available in the state, including information on personnel, spending, revenue sources, and information on identified gaps in services and overlapping service areas. And then also having the EMS Advisory Committee provide recommendations for the design of a statewide EMS system, the number of specific things they're supposed to report on that as well.
This one came to us from GovOps.
Yes. It allows them the EMS Advisory Committee to hire a project manager and one or more consultants with relevant expertise in EMS design and financing to help them get work. And gives them assistance from the health department. And then 2 reports, December 15th of 2025, they provide their inventory and assessment of existing services, and December 15th, 2026, they provide their design recommendations. All right, we're about to get to the real money part.
What page are we on?
We are on page 12.
Right there, okay.
All right, great. Section 7, the Vermont Fire Service Training Council. In the existing statute on the Vermont Fire Service Training Council, there are amounts assessed to insurance companies that write property and casualty insurance.
And we changed that in 310.
Yes, so you're changing it here too, and I think Nolan can speak to how these work together. So you're familiar with the concept. This is increasing the amount by $300. So the total amount that is raised for the operation of training facilities and curriculum of the Vermont Fire Service Training Council would go up from 1.2 million to 1.5 million, so $300,000 increase. But all of that increase goes to the allocation for the Emergency Medical Services Special Fund, which would increase that.
I just want to make sure that figure is the increase we did in 210.
So for the record, Nolan will join fiscal office, and Chris and I have been talking about this. I think that they're the same differences. This is effective on passage. That one's effective 7/1. Otherwise, the language is the same.
Yeah, Christopher Joint Fiscal, Madam Chair, Nolan's exactly right. The House in 310, and S 310 harmonized the increase. So the Senate's version of S 310 had that being a $150,000 increase.
Okay.
The House bumped it up to 300,000. So the language that you see in sub 4, and I think it was sub 1, that increased it by 300,000 and dedicated it fully to the EMS fund is exactly the same in the 2 bills.
So we're only raising there once.
Correct.
Yes, so because these are both amending the same statute in the same way, when these are kind of harmonized for codification, it'll just be the same one section of statute that has been amended.
We're just not doing it. Okay.
Right, but we are spending money in this one, so
That has got to go across the hall.
S 310 contained no appropriations from the fund.
Right.
So it only harmonized the increase.
All right, so this one has in section 8, we have the 74,000 in global commitment, that's the gross funds in FY 25 to Department of Vermont Health Access for that increased reimbursement rate for the treatment without transport. Of that, 31,206 is general fund and 42,794 is federal. Section 9 is the appropriation for the EMS Advisory Committee that comes out of that Emergency Medical Services Special Fund, so it takes a portion of the increase. It says notwithstanding any provision of the EMS Special Fund statute or that Fire Services Special Fund, Fire Safety Special Fund statute to the contrary, of the fund allocated to the EMS Special Fund under that provision we're just looking at that is being increased from 150 to 450,000. The sum of 150,000 is appropriated to the Health Department in FY 25 to support the EMS Advisory Committee in doing the work set out for it in section 6. And to the extent that there are unobligated funds remaining in that EMS special fund in FY 25, up to an additional 220,000 is appropriated and shall be made available to the Department of Health to support the EMS Advisory Committee's work, provided that the total expenditure from the fund to support that work cannot exceed 370,000.
Okay. So our job here is to reapprove what we did in 310. The rest of it is appropriations of what we're raising. And Sebastian is here. Sebastian.
Hi, good afternoon.
Good afternoon. That's all. It's good evening, I think, at this point. So tell us what we need to hear, and I think we can put this one away.
Hi, good evening. Sebastian Arduengo for the Department of Financial Regulation. we do not have a specific issue with raising the amount to be raised for the Fire Service Training Council. Because the amount is spread among many different lines of insurance. Of course, we haven't had the opportunity to do any kind of study to see how this would impact rates, but because it is a $300,000 spread among everything, we anticipate it would be de minimis.
Okay, we like that really de minimis. Okay, committee, any questions for Sebastian? Whose turn is it?
Oh, so are we?
Senator McCormick had his hand up.
So you want, who's trying to like give the report?
I'm looking for a motion to approve.
Oh,
the
okay.
bill,
So.
Because I hope we've got people waiting out there. This is our last bill. We have one report after this.
My question is, do you want, there is a good ops amendment.
There's a good option in it as well. In fact, it was-
So I don't know if you want to look at that and then approve
Can you-
bill as modified by the good ops.
Okay, can you do 2 minutes worth?
Yes, I should be able to do even less. I will put up the health and welfare one first, which I described as when we got there. And that is in that language about reporting on what it would cost to increase other Medicaid EMS rates to the Medicare rate. We struck out Medicare basic life support rate and they put in applicable Medicare rate.
Okay.
And then the Gov Ops amendment is in section 6, which is the EMS advisory committee work. And that they wanted to add language saying, looking at language that aligns with the purpose expressed in that purpose section at the beginning of the EMS chapter, optimizes patient care and incorporates nationally recognized best practices. And then in subdivision, when they added subdivision C2, they wanted to make sure that the EMS advisory committee and health department were going to coordinate with the public safety communications task force, the dispatch task force, and county and regional governance study committee that's in a bill that's moving through the process to ensure appropriate coordination and alignment of the group's recommendations and system designs.
Okay.
Now there are amendments that have been placed on it, having looked at them. I don't know if we can find out whether there's fiscal implications, but we can be voting on the.
Don't know, one of them is a report, is changing the language in a report, so that won't change anything. The other is making sure that there is coordination.
Right.
I'm looking at Nolan, but I wouldn't expect that the EMS advisory committee coordinating with other task forces would have a fiscal.
We're not raising any money.
And it doesn't, right, you don't really
Costs,
cost.
they've got to cover it.
Very good.
Okay.
So assured, I would say, I would move that Senate Finance Report February 6.2 is passed by the House.
What, no,
No,
as amended by Health and
Senate
Welfare.
committee.
Okay, there's,
As presented to us with the amendments from Health and Welfare.
okay.
And Gov Ops. The
We-
bill as it was presented to us. The reports.
The trick is then we have this string of draft numbers that I don't, you can minute for this. Ring.
What's posted on.
Okay, well, I can do the gov op on consent.
Yeah, that one's 1.1, they're both 1.1s.
Can't find yet.
The health and welfare one is from April 17th.
It's on our ready.
We're dealing with the bill as it was sent to us, amended. So we are moving to approve the bill as it was referred to us.
Okay. So then we're 2 amendments deep and that's.
Those amendments were passed, right? Yeah, so they were part of the bill as it came to us.
By operational rule.
Senator Franny moved to report the bill favorably when amended as recommended by the Senate Committee on Health and Welfare and the recommendations by Senate Appropriations.
That's
Great.
There we go.
Okay,
If you want details, I have them,
okay,
but they're a little tricky at this point. Three sticky.
I think we've covered it. Oh,
Wait till.
vote?
now. Oh, okay, yes, yes. Okay, I've got a motion on the floor that we amend the bill as it was presented with the amendments from health and welfare and government of impact. Further discussion? If not, all those in favor say aye.
Aye.
Opposed say no.
I have unexpected elsewhere.
Okay, I think you would know.
What's that?
I was hearing that 7-0, but your hand went up, or you would
No,
know.
that was just to explain
Okay.
why I'm leaving.
Okay, I think we're gonna
I don't wanna be rude.
I think we're gonna take a 5-minute break. I'll see if we've got anybody in the line. Pardon? Reporter on this bill. Who would like to report this? Okay, thank you. All right. We're gonna take a 5-minute break, stretch your legs. I'll see if there's anybody at the hall and then we'll come back. We'll do the amendment. We'll look at the amendment and there's all kinds of things I guess happening